Questionable, but it was done at his house, and I am looking into getting it.
At his house in the garage, baby?
Yes.
While everybody's drinking and smoking? I don't know. And what's with the tattoos on the arms and
It's a
stuff?
tribal tattoo and my daughter's name
Okay.
from an Indian reservation. So they did this at like we're crowd dancers. So yeah, it's kind of.
So you say you have your daughter's name?
Yes, right there, Alexis.
All right, here's the thing about having children. If you put one name on there and you don't put the other.
I know, I gotta get my roots.
So, well, here's my thing about tattoos. If you're going to put name. Assault with a deadly weapon. And they found you guilty of count 2 of unlawful possession of a firearm as charged in count 2. And you elected to come to the court for punishment. Are both parties ready to proceed with this phase of the trial, State?
Yes, Your Honor.
Defense?
Yes.
All right, State, if you would read out the enhancements.
All right, folks, let's pause here. The court is moving into the punishment phase, and already, we see a high-stakes setup, 2 serious charges with prior convictions stacking on top. If you're wondering why a courtroom can feel like a chessboard, this is it. Every move counts, and the defense is on the clock to respond. Buckle up, because the enhancements they're reading next. That's what can turn a decade behind bars into multiple decades.
For count 1, before the commission of the alleged offense in clause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996, and cause number 94 CR 5960 in the 187th District Court in Bexar County, Texas, the defendant was convicted of the felony of aggravated robbery with a deadly weapon, the gun. And before the commission of the primary offense and after the conviction in clause number 94 CR 5960 was final, the defendant committed the felony of assault, family violence enhanced, and was convicted on the 29th day of January 2013 in clause number D-1-DC-12-904-040 in the 427th District Court in Travis County, Texas. For count 2, the state is alleging that the defendant is a repeat offender, and so before the commission of the offense alleged in clause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996 in clause number 94 CR 5960 in the 187th District Court in Bexar County, Texas, the defendant was convicted of the felony of aggravated robbery, deadly weapon, gun.
All right. With regards to the enhancements in count 1, both enhancements, how do you plead? True or not true?
Not true.
And with regards to the enhancements as read for count 2, how do you plead?
Not true.
All right. Are there any opening statements from either side?
No, the state will waive opening.
Waive opening.
All right, State, you may call your first witness.
Preliminarily, the state, that Your Honor, the state would like to offer and admit all testimony and evidence that was heard in Nicholson's basic trial.
I believe the judge can take judicial notice of those things.
All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well from the prior testimony.
And all the exhibits as well.
Yes.
Okay, then the state would also offer State's Exhibit A into evidence, pending any objections from the defense counsel pursuant to Rule 902.
I object on lack of proper foundation and link to defendant and hearsay.
All right, the objections as it relates to hearsay, those will be overruled. It appears to the court that State's Exhibit A is a self-authenticating document. However, with regards to whether or not this is connected to this defendant, then that objection will be sustained.
And Your Honor, if the state could respond, the state would respond that goes to weight, not necessarily admissibility. It is a self-authenticating document.
No, I'm overruling her objection as far as that this document is not what it purports to be. It is self-authenticating, but what the part of her objection that I'm sustaining is that State's Exhibit A has not been tied to this defendant.
Well, yes, Your Honor, I understand that.
So foundation will have to be laid to somehow tie this document to this defendant.
Please tell the court what your area of expertise is.
Okay, now we're diving into fingerprint analysis. Here's the thing, fingerprints might sound like CSI drama, but in court, it's all about linking evidence to the defendant beyond a shadow of a doubt. Notice how the expert is careful to separate self-authenticated documents from a direct link to the defendant. Little details like this can make or break a case. Keep your eyes peeled, because procedural nuances like this are why lawyers lose or win battles before a jury even steps in.
I'm a fingerprint examiner for the Bexar County Sheriff's Office.
And at least you possess some.
Yes, I have a certification in classifying fingerprints as well as identification.
Please explain what those.
So we go through a rigorous course to understand the characteristics of fingerprints as well as on-site training to understand fingerprints.
Let's talk about specifically what is it?
A fingerprint is a print that consists of 12 characteristics that can identify an individual.
Have you ever found two different people to have the same set of fingerprints?
No, not from my knowledge.
Can you please explain how you do a fingerprint comparison?
So when we first get the fingerprints, we do look for, like I said, the 12 ridge counts, and we will compare to see if the individual that we do have in custody is the same person that is on the fingerprint itself. And then we do our handwritten classification that classifies the specific characteristics of the fingerprint.
Is your way of doing it, or that this kind of?
That's the standard.
That's the what way?
The standard.
Can you take the witness on board already?
Yes.
I may be a little confused. This exhibit B, when were those prints taken?
These were taken today.
And so when you were saying that those prints were taken by me, is that the one you were referring to?
Correct.
Okay. And so there's some other prints in the packet, right?
Correct. They're on the back of it.
Okay. But you were not saying you took those prints?
No, I didn't.
Okay. So you don't know my client, right?
No.
So you can say that the prints match, and you can say that you took the prints of my client today, correct?
Correct.
But you weren't present when the prints were taken originally.
No.
And so you can't say you didn't witness that, who the person was who gave the prints.
Correct.
Right. I would object to relevance and lack of affirmative link to my client.
All right. And so is the testimony,
I'm sorry. Sorry.
was it established who these prints and State's Exhibit B were taken from?
I'm sorry, Judge?
Was it established who the prints were taken from in State's Exhibit B?
Yes.
You did test.
What individual? Do you want to, yes.
Ms. Valdez, you testified that you took the fingerprint stakes of the B today, correct?
Correct.
You see the person in the photo that you took those fingerprints from?
Yes.
Could you please point to that person identifying on our photo?
The gentleman in the red.
And represent the record reflect that this is identified the person that you took the fingerprints from, 6 Exhibit B.
All right. Defense, any objection with regards to State's Exhibit A and B?
Every urge the same objections, Your Honor. She has no knowledge of the person who gave the original print.
All right, those objections will be overruled. State's Exhibit A and B are admitted over defense counsel's objection. State, any other witnesses?
No, Your Honor, the state will rest.
Defense, any witnesses?
No, Your Honor.
Defense, do you rest?
Yes.
State, do you close?
Yes, Your Honor.
Defense, do you close?
Yes.
All right. As previously stated, the court is finding the enhancements true. And the court is finding the enhancements true that were read into the record for count 1, and also the enhancements true that were read into the record for count 2. The court will hear argument with regards to sentencing. Mr. Nicholson, you are not eligible for probation from the court. All right.
Yes, Your Honor. The state would like the court to consider State's Exhibits 39 and 40, which was entered in the guilt phase of trial. That's going to be the judgment from Austin for the conviction of assault enhanced. And additionally, the fingerprint part of that was linked to that judgment in the guilt phase of trial. Your Honor, this defendant does have a very lengthy and violent criminal history. In 1996, he was sentenced to 20 years for aggravated robbery. That's going to be cause number ending in 60 that we entered in today. He was additionally sentenced for burglary of a habitation on that same day. That's going to be cause number ending in 59 that was entered into evidence today as part of State's Exhibit B. State's Exhibit A. Your Honor, he was sentenced in 1996 to 20 years in the Texas Department of Corrections for those crimes. When he was released, it was not very much longer until 2013 that he committed the offense in State's Exhibit 39 for assault enhanced, where he was convicted and sentenced to 6 years. So in 2019, after the 3 years are done, it took him 3 years to commit this offense, this violent offense, where he shot at an unarmed Uber driver who just happened to be picking up his stepdaughter so that she could go to work. Thankfully, nobody was hurt in this offense. But that.
Okay, now we're diving into fingerprint analysis. Here's the thing, fingerprints might sound like CSI drama, but in court, it's all about linking evidence to the defendant beyond a shadow of a doubt. Notice how the expert is careful to separate self-authenticated documents from a direct link to the defendant. Little details like this can make or break a case. Keep your eyes peeled, because procedural nuances like this are why lawyers lose or win battles before a jury even steps in.
Just luck, Your Honor. The capacity for this defendant to hurt people in this community, to hurt his family, is shown by the criminal history, and the state is asking that the court sentence the defendant to no less than 40 years on count 1 and no less than 20 years on count 2.
Defense?
Thank you, Judge. I know that we've heard about his criminal history and the seriousness of it. I did want to offer some context to that, which starts with the fact that the first offense that for which he did the 20 years, he was actually age 16 when that happened. And he was certified as an adult and sentenced, and he ended up doing most of the time. He really lost so many of his formative years at doing that time, right? And then he gets released and is having trouble, and has continued to have trouble adjusting. And the second case, the family violence assault case, he pled to, and he acknowledges, and I'm not saying he doesn't acknowledge the first case, but he does ask, and we do ask the judge to consider how young he was at that time. I have had contact with 2 of his family members, siblings, who were not able to be here today. One was a Mr. Paxton, and another is his sister, Samantha Lomborg. And if I may, they both relate to me the chaotic and troubled childhood that they had, and how, in spite of what you see here today, that Mr. Nicholson was actually a loving and caring brother.
I'm sorry, do you want those witnesses here?
No, I think we discussed it.
No objections from the state.
That their father was a drug addict, and all the children in the family suffered tremendously, and that Dominic felt an enormous responsibility to try to provide for his siblings, which led him to make very poor choices to accomplish that goal, but that his actual motivation, and led him into down a criminal path, which I guess partly was role modeled by his father, but also his sense of duty and obligation to his siblings and having very limited ability and resources to provide for them in his overwhelming sense, that he should try to provide for them, really hindered his thinking, and obviously has made extremely poor judgments. I know we stand here today, the jury heard the evidence and returned their verdict, but Mr. Nicholson believes that he can return to society and be rehabilitated. This has been a long revolving door in his life that he is very tired of. And so we would ask the court to please sentence him at the minimum range.
All right. State any final closing argument?
Your Honor, the state does appreciate that Mr. Nicholson was young when he committed the first offenses. However, I think that just speaks to his criminalities as prior life. Although the hopes for change are there, according to defense counsel, his actions speak louder than his words, and the court would like the state would like to consider those actions the harm that he could have caused on October 10th, 2022, that he has caused throughout his life.
All right. Is there anything you would like to say?
Yes, ma'am.
Here's the thing. If you want to say something, I'll take you under oath and the state will be allowed to question you. I mean, if you want to discuss it more with your attorney.
I like to be open like this. Not being able to say it.
No, I mean, we can go off the record. Here's the thing. Once you decide to testify, and I think your defense counsel will tell you there are certain appellate issues that may or may not be waived. So it's completely up to you. If you want me to hear what you have to say, I will hear it. What I can tell you with regards to my clients, sometimes they would want to speak, and I would tell them, your family has already told your story. Are you going to say something different than what your family has said? So the state was very generous in allowing your counsel to make a proffer to the court about your childhood. So, but if you would like to say something, it's only fair, because I want to be fair to both sides. You don't get to just say something and then that's it. What will end up happening is I will swear you in, you'll be under oath. And if you just want to speak generally to me, you can speak generally. I'm not going to sustain any objections for narrative, because sometimes people just want to tell me what their thoughts are and I will listen to them. But that being said, whatever your thoughts are that you want to make sure that I know about, then the state will be allowed to cross-examine. So if that's what you want to do, then we can do that.
I've seen it. I hope. Thank you.
All right.
I guess I would say, I know he feels like he's really in the fight for his life here. And
No, we're not on the record yet.
Okay.
No, we're still off the record. Yeah. All right. So y'all ready to proceed? All right. We're back on the record. All right. Mr. Nicholson, this is what I want you to know. No matter what offenses people are alleged to have been committed in this court, it could be offenses that people think are the worst of the worst. I still see everybody as a human being. And when I look at them, many a times I see them when they first start school, like first grade. And I always wonder what made this one child turn left instead of going right. Some people have horrible childhoods and they turn out great. They have a horrible childhood and their thing is, I'm not going to be this way. I'm going to be on a straight and narrow because I need to do this and that. Some people can't overcome it. You know, life just beats them down. And sometimes when you watch movies, when we were growing up, we would watch movies and you see these two children and you think,
Here comes the human element, judge's perspective time. Notice how she pauses to break down the defendant's life trajectory, childhood, prison, societal barriers. This isn't just courtroom drama, it's a subtle psychological insight into why people reoffend. Judges often weigh these factors against punishment, but at the end of the day, society demands accountability. It's a delicate balance between empathy and justice, and you can feel the tension in the room.
Thinking everything's going to turn out great for them, and there's one pivotal traumatic thing that happens in their life, and it gets them off track, and they're never able to get it back in. For example, with you went to prison, right? People will go to prison, and when they get out of prison, they say they're going to do great things. They're not going to get in trouble anymore. They're going to walk the fine line, right? You get out, you say, I'm rehabilitated, and you say, I'm going to get a job. And then when you try to get a job, people look at your history and they say they're not going to give you a job. And so that's one way where society beats you down. And then you keep trying and you keep trying. And then maybe there's a friend who comes along or somebody who comes along and said, hey, here's some easy money. And maybe you have siblings that you're trying to take care of, try to make sure they don't have to go through what you went through. But at the end of the day, we all got to pay for our offenses, right? Now, do I think that you should get life in prison? No, right? Your minimum is 25 on the first on count one. It's from 25 up to life in prison and up to a $10,000 fine. All right. This is what the court is going to do. The court is taking in consideration the state's argument about his history, because I have to consider that. But then I'm also taking into consideration what the defense said. And I think everybody would agree for someone to be 16 and to end up being sentenced to 20 years in prison. And I'm assuming he did the 16 when he was at juvenile, but once he became an adult, they sent him to prison with adults. So for a child to end up in prison with adults who have all of their issues, I'm sure they looked at him a certain kind of way. But even though that happens, we can't be in a situation where life has beat us down, so therefore we're going to beat other people down, because then it just becomes a circle. So all of the offenses that you've committed, guess what? That complainant has been traumatized. So there has to be punishment, and you're not eligible for probation. And based upon what I've heard during the trial and based upon what I've heard during this punishment phase, I would not grant you probation, right? Even if you were eligible, because I don't think you're a good candidate for probation. But I also don't think you should spend the rest of your life in prison. All right, so in count one, as previously stated, I'm finding both enhancements true. In count two, I'm finding the enhancement true. In count one, I'm going to sentence you to 30 years in the prison. In count two, I'm going to sentence you to 20 years in the prison. The counts will run concurrently. There's an affirmative finding of deadly weapon in count one, and there's to be no contact with Jayla Satterwhite. Is there anything else with regards to sentencing from state or the defense?
No.
All right, and the court will order affirmative finding of family violence.
And I assume the court will be giving him credit for all time served.
Yes, and you'll receive credit for any time served that you've been in custody. And counsel, if you believe the credit is incorrect, just let the court know. We'll make sure that it's corrected. And for some reason, I do not have the trial court certification. I'm sure you probably filled it out before, but do you mind filling out another one for the court?
Okay.
Yes, it's on the wall. And she's going to give you a document that's entitled Trial Court Certification of Defendant's Rights to Appeal. You do have a right to appeal because this is a jury trial that occurred. Do you understand? All right. Your counsel is court appointed, so what will end up happening if she withdraws from your case, a new attorney will be appointed to handle any appellate issues. Do you understand?
Yes.
All right, because this is an affirmative finding of family violence, and also because these are felony convictions, and you should know by now, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, do you have any questions about anything?
Just, I didn't hear you. I don't know if you were doing it or not. The fines.
No fine.
Thank you.
All right. Here's your document.
Thank you.
You're welcome. We can go off the record. So, Mr. Nicholson, I know. It's a lot of time, right? And you have to do half before you're eligible. But guess what? At the end of the day, it's not the end of the world for you, right? You're gonna be older when you are released from prison. There's no ends, ifs, or buts about it. But you can still take this time to try to better yourself while you're at the prison. You can still get degrees. Young people who come into prison, if they're not acting crazy, you can probably give them some advice to help them do better and be better. And you're still alive. You can still pick up the phone, call people. You can still write letters to people. Hopefully people will come visit you at the prison. You can still have that. As long as we're alive and breathing, we have the opportunity to change. You understand?
Yes, ma'am.
So it can still be done. You can still come out and do great things. All right? All right. Good luck to you. We're going to see you back on Tuesday, okay?
Okay,
All right. Thank you.
thank you.
We're off the,
You're welcome.
off the record.
Yes.
Okay, so this has been a matter of logistics on the appeal.
Yes.
I'd file a motion for new trial and then wait to file the motion because I'm not on the appellate wheel.
Well, what we can do is we can take that up on Tuesday
Okay.
because you'll still have enough time. 30
Okay.
days will not have
Right.
expired.
I just want to make sure I get it in the right order
Yes.
because I think there was a particular order on the motion to withdraw on the file.
Yes.
Okay.
All right. Thank you. We'll see you back on Tuesday.
Okay, thank you.
Thank you. You're charged with the offense of theft of a vehicle, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Evidence to find you guilty, the court will defer finding the guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we're just asking that you follow the plea agreement.
All right, Mr. Rodriguez, how old are you?
24 years old.
All right, and what's your relationship with Crystal?
She's a cousin through marriage.
What's your drug of choice?
It used to be marijuana, but I'm 2 years sober.
And what else?
Just alcohol, but I don't drink anymore. I have type 1 diabetes.
Okay, alcohol, marijuana, what else?
That's it, Your Honor.
Why are you taking a vehicle that doesn't belong to you?
I don't know how to drive. It was kind of a misunderstanding. She picked me up. I was a passenger.
No, there's no misunderstanding. Do you want a jury trial?
No.
All right, because there's no misunderstanding. And here's the thing. I tell people this all the time. You're going on a joyride. You don't know what people are going through and what is happening in their life, right? The person's vehicle you took, did you read the police report? You know what it says in here?
Yes.
It says, on January 26, 2023, Stephen was unloading his vehicle after attending a funeral. So you
Moment of reality check. Imagine going to a funeral and then coming out to find your car missing. The judge is painting this picture to remind us, and the defendant, that crimes aren't just numbers on a sheet, they're real people, real consequences. This is why victim impact and context matters in sentencing. It's about connecting the dots between personal actions and their ripple effects.
Can you imagine? His mind is elsewhere. He's just attended a funeral, which means somebody has died. Probably somebody that he cares about, because I do know some people who just show up for funerals because they're professional people who show up to funerals. You know, they're like, oh, this person died. Let me go to their funeral and see what everybody's wearing. But normally, when people show up to funerals, it's usually a loved one or somebody they had a connection to. So he's going through all of that, probably not even thinking, leaving in his car, keys in the car to just go in and talk to people for a few minutes, and he comes out and it's gone. Because you and Crystal just want to take something that doesn't belong to you. These are material things. Do you understand?
Yes, sir.
And if you can't afford it, then walk. Get some fresh air. Take the Via bus. I used to take the Via bus, and I love walking. You can't tell it by my weight, but I do love walking. All right. So do you have any children?
Yes, Your Honor.
Age?
Oldest is 9, and youngest is 3.
And who are they with?
Right now, they're residing with their mother.
When's the last time you had contact with them?
I want to say about 2 months ago.
From jail?
Since he's been in jail. I mean, he's had contact with them all along, I believe, until he was arrested. Well, not recently, but
How far did you go in school?
I got my GED.
So what are you planning on doing with the rest of your life?
Planning on getting into construction.
Yeah, but I mean, you have plans how you,
I was going to get into pre-criminal justice. I'm with the Indian reservation that provides college and schooling.
so what are you doing with criminal justice?
I was thinking about becoming a lawyer.
Well, I'm sure your attorney will tell you any occupation in Texas or anywhere else that requires a license, you have to pass a background check. And they may look at this and say no. So you may want to look into that before you spend money. Law school costs at least $100,000. Okay, defense, do you have any recommendation? You're asking for length of probation time?
I believe that we were both asking for 2 years for adjudication.
All right.
Prosecution as well as the defense.
All right, well, I'm going to keep him on a little bit longer, but of course, if he completes everything early, the court will consider early termination. So whether or not you're on for 3 years or 2 years is up to you, okay?
I'm willing to do as long as probation, as much probation you need to give me.
All right, and if you're released today, where are you going to be staying? With who?
I'm going to be staying at my aunt's house.
All right, did your aunt want you there?
Yes, she does.
Did you talk to her and ask her, can I stay?
Yes, I kind of like help with her friend, helping her being a caretaker, and she's helping me with my diabetes.
All right, and what's this tattoo on the side of your face? What is that a tattoo of?
It's a cross, Catholic cross.
All right, why did you do that?
It was supposed to be smaller, but the guy kind of did it.
Let me see it. But did he just freehand it? Because usually, and so you had no idea what was happening.
I had no idea until I looked in the mirror and I was like, dude, it was supposed to be a smaller cross. I was like, this is my face I gotta live with it, you know? Yeah.
Well, you can always get it removed. Was this a professional?
He said he was a professional, but it was done at his house, and I am looking into getting it removed.
At his house in the garage, baby?
Yes.
While everybody's drinking and smoking? I don't know. And what's with the tattoos on the arms and stuff?
Tribal tattoo and my daughter's name.
Okay.
From an Indian reservation, so they did this at like we're crown dancers. Yeah, it's kind of.
So you say you have your daughter's name?
Yes, right here, Alexis.
All right, here's the thing about having children. If you put one name on there and you don't put the other.
Oh, I know, I gotta get my others.
So, well, here's my thing about tattoos. If you're gonna put names on it, usually the safe bet